Hi, it's Wendy Hernandez with Command the Courtroom. In this week's video, I'm going to give you an anatomy of a family law case. I just want to give you a roadmap of what a family law case is going to look like from start to finish. So to get a family law case started, somebody has to file a petition in court. And a petition might also be known as a motion, or a petition might also be known as a complaint. Regardless of what it's called in your jurisdiction, whoever files the petition is often called the petitioner. That is the person petitioning the court. And there are some jurisdictions where the petitioner might be called the plaintiff. The person who has not petitioned the court is called the respondent or the defendant. That person is the one who's receiving the petition or is being served with the petition. So if you are the respondent in a family law case and you have been served with some sort of petition or complaint or motion, you have to be aware that there are usually certain deadlines by when you have to respond. And if you don't respond in a timely basis, then it's very likely that the petitioner or the plaintiff is going to get all of the relief that they're asking for in the petition. And that may not be a big deal if you agree with everything that they're asking for in the petition, but if you take issue with even just one thing, you really need to file a response and you need to do it in a timely manner. Otherwise, the other side is probably going to get what they want. So to figure out what the time deadlines are in your state, I would check your local rules, consult with an attorney, do some research on the internet, but just whatever you do, respond in a timely fashion. So once the petition has been served and the respondent has responded to the petition, then you enter the part of the case that is called the discovery phase. And this is where parties are exchanging information with each other and they're disclosing information to each other. They're letting each other know what their respective theories of the case are and what the evidence is that they are going to use to support the case. They're working their cases, in other words. So the length of the discovery process really depends on the issues in the case, and it also depends on your judge and the jurisdiction. Sometimes cases are really simple. There are not a lot of issues, or the issues are very straightforward. And in those cases, I would say the discovery time period is, could be pretty short. In Arizona, for example, for non-complicated cases, the discovery period might only be a couple of months. And after a couple of months after service, the judge might set trial and the case could be resolved. But in cases where the issues are more complex, if custody is at an issue, for example, or if there are businesses involved in the case, or if somebody wants mental health evaluations done or vocational evaluations, and there are just more complex issues, then the discovery process could really last a long time. It could last for months, it could last for over a year. And I've had a couple of cases that did actually last a couple of years, and those cases were cases that had some pretty serious issues. The parties had multiple businesses, multiple pieces of land. They had been married for quite a long time. Their spousal maintenance was at issue. There may have been child custody at issue. There were mental health issues. So those are the extremes, I would say, those cases that last a couple of years. But in any case, if you want to shorten the amount of time that it takes to resolve the case, then you can do your part by attempting to work with the other party and compromise on issues, the big issues that are important. And it's not always possible to compromise, I understand, because it takes two people to compromise. And if you're the only one willing to compromise and the other side isn't, then you just can't settle a case, and you have to work the case, and you may end up having to try the case. But if you do end up working the case out, then what is normally possible is you and the other side would prepare what's called a consent decree of dissolution, or a consent judgment if you're not doing a divorce. And you submit this consent judgment or this stipulation to the court for the court's approval. And in this paperwork, you would have all of the agreements that you've reached with the other party. And normally you and the other party would both sign the agreement. And if there are attorneys involved, they would sign the agreement, and it goes to the judge, and the judge hopefully would approve it if the judge found that the agreement was in the best interest of the children, and if the judge found that the agreement was fair and equitable. Now, say there are some issues that you agree on, but there are other issues you do not agree on. Well, it is possible to reach agreements in writing or on the record in court on those issues that you're on the same page with the other party about. With respect to the issues that you don't have an agreement on, If you can't reach an agreement on those, then you end up in trial, you end up in front of a judge, and the judge has to make the final call. So at the trial, as you know, if you've watched any of my videos, you would be presenting evidence to support your case, and the other side would be presenting evidence to support their case, and the judge would ultimately make the decision that he or she thinks is best. So that's the way that a case goes. A petition's filed, a response is filed. If a response is not filed, then the case goes to default, and the person who's petitioned for a certain form of relief gets it because the other side never responded. If a response is filed and the parties agree, then they submit the agreement to the court for approval. If the parties can't agree, then they end up going to trial. Keep in mind that as a case is pending, you actually can try to settle it through alternative dispute resolution, which is also known as mediation, or by going to a settlement conference, or in your jurisdiction there may be services available through the court. In Arizona, we have services available. They're called conciliation services, where you can go and they can help you work out certain issues. So always try to resolve your case if you can. It's always better to resolve it on your terms rather than having somebody who's a total stranger to you and your family resolving it. The timeline to resolve cases, again, it just depends on a number of factors: the complexity of the issues, the judge's docket, your jurisdiction. A case can be resolved really quickly in Arizona. There's a waiting period in divorce. It's a 60-day waiting period after the date of service, but after that, the divorce can be final quickly. Other types of cases not involving divorce can be resolved very quickly. More often than not, I see cases in a time frame of 6 to 8 months before they're resolved, and for the extreme, the more complex cases, it could be a year to 2 years. So that's my anatomy of a family law case. I hope this helps break it down and helps you understand who you are in a lawsuit, whether you're the petitioner or the respondent, and really hits home the point that if you're the respondent, be aware of the deadlines and file a response if you take issue with something that's been filed in the petition. Remember, I'm Wendy Hernandez with Command the Courtroom. Keep your questions coming. Don't forget to like Command the Courtroom on Facebook. If you haven't already subscribed to my channel on YouTube, I post helpful videos every single week. Check out Command the Courtroom if you have not. CommandTheCourtroom.com if you have not already downloaded my best interest checklist. I will keep the videos coming. And until next week, go out there and get them, and remember to command the courtroom.